Wait a little bit. I see. Okay. And you can proceed now.
Thank you. Thank you very much. Honorable Chair, good morning again, Honorable Chair, honorable members. Just 2 points before we start, just to say, I've spoken to our parliamentary liaison lady who confirms that we always submit our reports on time. And we take this very seriously, the parliamentary process. And on the second issue, we were alerted that we may get questions on the issue of Paul Pretorius. So as the chair had indicated earlier, we are happy to take questions in that regard as well later. Chair, if I may now proceed with the report itself on the Omotoso matter. Let me firstly say, Honorable Chair, honorable members, that as the National Director of Public Prosecutions, as the NPA, we firstly want to express our deep disappointment and to a certain extent outrage, like the public, like many people in South Africa, about the outcome of the recent judgment. This has been unimaginably devastating for the victims in this case. And as lawyers for the people, we, the prosecutors in the National Prosecuting Authority, we serve and we represent victims in court cases. So this has been devastating for us as the NPA as well. But more so, it has been a blow to all our efforts, together with the efforts of many others, both within government and outside of government, in trying to address the scourge of gender-based violence in South Africa. I do want to emphasize, though, that although this judgment has been a major setback, I urge that it does not detract from the really important work that is being done and the support that the NPA and its partners in government, outside of government, constantly provide to victims of sexual and gender-based violence, including in the most complex cases. And I'll revert to this a little bit later. But firstly, in view of the devastating impact of this case, we immediately took measures to ensure accountability and that justice prevails, always within the confines of the law. As we've set out in the report that we submitted to the committee on this past Monday, the 12th of May, we've undertaken 3 key measures. The first one is that we put in place steps to explore the grounds to appeal this judgment. Secondly, we continued with an investigation that had already started in August of last year into the conduct of prosecutors that are involved in this matter or were involved in this matter. And what we also did after the judgment is that we enhanced the capacity of this particular team. In addition, the third key measure is that we established a team to assess the prosecutorial performance in the Omotoso matter, to submit a report to me as the National Director and to look at, depending on what the report says, what are the possible interventions that are required to enhance performance of prosecutors, to ensure that we learn from this and that such does not happen again. But of course, it all depends on what the report says. Let me explain to the committee in a little more detail what these processes have entailed. Dealing with the team to explore grounds to appeal the judgment. As we communicated on Tuesday, 13th of May, 2025, publicly, the NPA's Director of Public Prosecutions in the Eastern Cape, Mr. Barry Modolo, has taken a decision to appeal the judgment of the Eastern Cape Division of the High Court in Gqeberha. In order to support the DPP in making this decision, on the 9th of April, 2025, as the National Director, I established a team that led by the Special Director of Public Prosecutions, in charge of the SOCA unit, Sexual Offences and Community Affairs. Advocate Bonnie Curry Gamble, who I mentioned, is on this platform. Also Advocate Cesar, who is the Deputy Director of Public Prosecutions in the Bishu office, who was part of prosecuting, who in fact led the prosecuting of this case. I appointed 2 other experienced prosecutors from outside of the Eastern Cape Division in order to carefully consider the judgment and the transcript, which runs into thousands of pages, and to provide advice on whether the judgment is appealable or not in terms of Section 319 of the Criminal Procedure Act. As you indicated, Honorable Chair, it is indeed so that as the state, the prosecution can only appeal on points of law and not on points of fact. We also decided that, and in fact appointed independent senior counsel from the Bishu Bar in order to also provide advice on this issue. And the reason why we also got senior counsel involved, which we don't normally do in cases, is that given the criticism that was leveled against the prosecutors in this case, we thought it was really important in order to protect the integrity of the process and to give confidence that we have external senior counsel that peruses the matter, applies their mind, and also renders an opinion on the prospects of success on an appeal in this matter. Unlike convicted persons who can appeal on the basis of fact and law, as I said, the state can only appeal an acquittal on a question of law. The team studied the full transcript of the matter, and they compiled a memorandum of advice. They all unanimously agreed that there are sufficient grounds to appeal the judgment. The team identified several questions of law, which the trial court, in our view, should be asked to reserve for consideration by the Supreme Court of Appeal. They provided extensive motivation for arriving at each question of law. This memorandum of advice was prepared independently of the external counsel's opinion. The team sent the findings to the DPP, Mr. Barry Modolo, who is the decision maker in whether to appeal this matter or not as the DPP in the division. On the 5th of May, senior counsel, having considered all the relevant documents, judgments, also provided an opinion on this aspect, and counsel opined that there are strong prospects of success on appeal. Counsel also identified several points of law for reservation, and is of the view that as a first step, it's necessary to request the trial judge to clarify and make available factual findings of the trial court. Once this is done, it may be necessary then to reconsider the identified and proposed questions of law for reservation. But we'll deal with that once we get the judge's clarification of the facts, which we have requested. On the 2nd of May 2025, the DPP informed me of his decision to appeal the judgment and to request the judge to clarify factual findings. The state attorney immediately instructed counsel. The relevant papers were drawn up and they were submitted to the Registrar of the High Court in Gqeberha on Monday, 12th of May 2025. And these papers relate to a request to the judge to clarify factual findings, as I mentioned. And once these are received from the judge, the NPA's legal team will then finalize the papers on the reservation of questions of law and file this application with the Registrar of the High Court. Even though Section 319 of the Criminal Procedure Act does not prescribe a time frame for filing of such papers, we undertake to file the application within a reasonable period to avoid any undue delays in this matter. The decision could not be rushed due to the complexity of the matter and the voluminous transcript that needed to be interrogated also by external counsel. We are of the view that there are reasonable prospects of a successful appeal despite the complexities. The Honorable Chair and Committee will know that whilst the legal process unfolds, Mr. Omatoso has been arrested and is facing deportation proceedings in terms of the Immigration Act 13 of 2002. So that's the steps in respect of the first key intervention. The second one relates to the investigation of the conduct of the prosecutors involved in this matter. So an investigation into the conduct of Advocate Ntelwa and other prosecutors, and I only mention his name because it has been in the public space. An investigation into their conduct started in August of 2024 with a view to identifying any possible misconduct. And as I mentioned, depending on the outcome, whether any disciplinary steps should be taken against any of the prosecutors. Because the judgment on the 2nd of April this year also criticized certain prosecutors, the scope of that investigation has been extended to focus on the entire prosecution team. And if the investigation confirms any possible misconduct, the matters will be referred to the NPA's Office of Ethics and Accountability, which is the OEA, to deal with those cases. In August 2024, and this now I'm talking about, I said that the investigation into this matter had started in August 2024. What happened at that stage is that a senior public prosecutor based in Johannesburg Magistrates Court was initially appointed to deal with the investigation into the conduct of Advocate Ntelwa and other prosecutors, but relating specifically to the mistrial. There might be a question about why this investigation started in August 2024 and not earlier, when it came to light that already in December 2021, that there may have been potential misconduct on the part of the prosecutors relating to influencing the witnesses in the main trial. That is, in fact, precisely why the decision to proceed with an investigation was delayed. It was taken by the DPP in consultation with the late Advocate Rodney de Kock, because the investigation of the prosecutor's conduct required that they will need to get statements from the victims in the main trial. And they did not want to complicate the issue. They were already going through a very complex and difficult time having to testify in the main case. So they decided to wait with the start of the investigations until they had completed their evidence in the main trial. In fact, at the time when the judgment was delivered on the 2nd of April this year, the investigator was in the final stages of the investigation, and I'm advised almost at a point when she could have compiled a report. But it has been now expanded, the scope has been expanded, and I'm expecting to receive the report. I have a timeline on that, which I will advise soon. But what we've done in the meantime, in order to expedite this investigation, is that on the 15th and 16th of April, we appointed additional officials to assist the original investigator because of the extended scope created by the judgment. The additional team members consist of a senior state advocate who has been released to focus on this particular investigation, and another state advocate, both of them from the SOCA unit, as well as a staff member of the OEA, that's the Office of Ethics and Accountability. The team is expected to finalize their investigation and have a report to the NDPP by mid-June this year. The findings from this particular team, as I said, will inform any possible disciplinary steps that need to be taken, and we will closely monitor this to ensure that the finalization is not undue delayed, and that we do meet the deadline of mid-June 2025. Coming to the third key intervention, that was the establishment of a team to assess the prosecutorial performance in the Omotoso case itself. So in light of the criticisms that were made by the judge regarding the seemingly poor quality, in particular of the cross-examination by the prosecutors and failure to adduce corroborating evidence, the NDPP established this team led by Advocate Bonnie Curry-Gamwell, the head of SOCA unit, as well as prosecutors with extensive litigation experience in gender-based violence matters, to meticulously examine the record of the proceedings and assess the performance of the prosecutors in this matter, particularly related to the aspects that the judge raised as matters of concern. This team, which is currently composed of 2 deputy directors of public prosecutions and 3 senior state advocates, they are doing the necessary work. The transcript is, I'm told, over 1,600 pages that they are looking at, and they expect to submit a report to me by the end of this month. Chair, those are the 3 key interventions that we've put in place to deal with various aspects of the Omotozo decision. But I'd like to advise the committee as well that immediately following the decision, the committee will recall that Chapter 9 institutions, that's the Commission on Cultural, Religious and Linguistic Rights, the South African Human Rights Commission, and the Commission on Gender Equality, held a media briefing in which they also criticized the work of the prosecution team and raised concerns about the impact of the acquittal. I immediately reached out to the heads of these Chapter 9 institutions and sought an urgent meeting with them. This took place on the 14th of April at the offices of the CLR. At this face-to-face meeting, we discussed the case. I reaffirmed the NPA's commitment to ensure that justice is done in the case within the confines of the law, and reiterated my, as the National Director, willingness to meet with the victims in this matter. It's important that I, as the National Director, and the leadership fully understand why the victims feel let down by the prosecutors in this case, aside from, of course, the devastating judgment, which we understand. And the reason for this is that as a National Director, I want to ensure that whatever happened must never happen again. We are lawyers for the people. And so we really want to understand this, take lessons, and make sure that any wrongs are corrected. So it's really important. We are engaging, we will engage more with the CLR, and hopefully when the victims are ready, they will be able to speak to me. We are committed to cooperating with any envisaged commission of inquiry that is undertaken in this regard. We really, if there's any good, perhaps, if one can call it that can come out of this case, is that there is a focus now on dealing with gender-based violence in this country. We know that this is a scourge, and we know that we are not winning this battle. So I think as the NPA, we feel that it will be really important to have a deep dive into why we are not winning this battle. Prosecutions come at the end, and it needs to be an all of society approach to how we can address the scourge. So we really welcome any such inquiry, and we will certainly cooperate and partner to the extent that we need to with such institutions to make sure we get to the bottom of this and fully understand this. Honorable Chair, honorable members, whilst in our appeal, we maintain that the judge has erred in certain of her findings. As I said earlier, this judgment has had a devastating impact on the victims and has seriously dented confidence in the NPA and in the justice system to address sexual gender-based violence matter. I want to emphasize that although this judgment has been a serious setback, I urge that it does not detract from the really important support and work that the NPA and its partners every day provides to thousands of victims of sexual and gender-based violence, including in the most complex cases. So for the sake of millions of victims in this country, and sadly, potential victims, because the scourge continues, I urge that we do not fuel the narrative that nothing is being done in the NPA to address the scourge or to support victims because of this case, because it is simply not true. More importantly, we really do not want to discourage victims from coming forward and trying to seek justice and from accessing the really good services that are provided. Very briefly, the Tutuzela Care Centers, which are the TCCs, led by the NPA, but in very strong partnership with various government institutions like the Department of Health, the Department of Social Development, of course, the police, as well as, non-governmental institutions, as well as working with business and the private sector, are world-class multi-agency facilities which provide the most comprehensive support to victims on their journey to becoming survivors. Thousands of victims are receiving such support from our country's 66 TCCs, which we plan to expand significantly over the coming years. The NPA achieves a 77% conviction rate for thousands of cases that are flowing through the TCCs every year that are successfully prosecuted. I say this and again want to emphasize, we do not want to minimize the impact of the Omotozo case, but we urge that it does not detract and deter victims from coming forward to access these services that are critical on the journey to becoming survivors. The TCC is but one of the prioritization initiatives in the NPA that's dealing with gender-based violence. The others include the Serial Rapist Prioritization Initiative, and we can give more details on this if we are required to. We can give reports to Parliament on this. The Teenage Pregnancy Prioritization Initiative, the DNA Prioritization Initiative together, which is being led by the SAPs, and we're working very closely with them on this. In fact, the Serial Rapist Prioritization Initiative, in fact, flows from the DNA Prioritization Initiative. Building of the court preparation capacity, which supports victims through their process to avoid re-traumatization in the court process. Contains sustained public awareness campaigns using different platforms, the building of GBV litigation capacity throughout in the different courts across the countries, upskilling of prosecutors, which is ongoing, and with a particular focus on trafficking in persons and child pornography. And Advocate Bori Karigamwo can elaborate on this later. And our focus in this particular area, that is trafficking matters, really it is the SAPs and the NPA working very closely, and which resulted in South Africa being removed from the trafficking tier watch list in 2024. We have some of the most experienced sexual and gender-based violence prosecutors in the world, sadly, because of the numbers of cases we prosecute, who know how to mount successful prosecutions. And this was demonstrated most recently by the team of Advocates Swanepoel and Hiraman, who together with our SAPS investigation team successfully prosecuted the case of trafficking in persons for the purpose of exploitation and kidnapping in the case of the little child Jocelyn Smith, who we really hope will be found soon. Another case involving the successful prosecution was that of a former police officer, Mr. Teku, who has been sentenced to 20 years imprisonment for raping a 17-year-old victim of domestic violence inside the Komka police station in the Eastern Cape. Moreover, interventions in respect of serial rapists that I mentioned earlier on have ensured successful prosecutions of several serial rapists. For example, in the case versus Prince Themba Shongwe, 9 rapes, 4 murders of children between the ages of 11 and 16 years in Mpumalanga. Sexual and gender-based violence remains an unacceptable scourge in our country. It's a crisis that, as I said earlier on, requires the whole of society response. But we understand our responsibility and we take it very, very seriously. And we will continue to provide the victims of crimes with the support that they need and the prosecutorial expertise to ensure that there is justice and perpetrators are held to account. Honorable Chair, honorable members, that is the report on the Omotoso matter. We do have colleagues that can expand on some aspects of this. If the Honorable Chair would allow, we can allow Advocate Bonnie Curry-Gamwo to expand on some of the initiatives on the NPA. But otherwise, we are ready to take questions, Honorable Chair, honorable members. Thank you.